My first question will, of course, go to Justice Jawad Hassan. Given that Pakistan's legal framework criminalizes the facilitation of child marriage, but remains largely silent on the legal status of marriages once they have taken place, how do you see the judiciary's role in interpreting this silence, particularly in light of our constitutional right to dignity, equality, and protection of children?
Thank you. Can you hear me? I welcome all the foreign dignitaries here and thank you for participating. This is a very important topic. The answer is into four kinds, it's in 5 minutes. First, importantly, is the legal anthropology of child restraint law. This is a law is 1929. Almost as old as its legislature. And unfortunately, the legal anthropology of this law, after the 18th Amendment, not a single province has made the legislation in the own province because of some issue. Law has, if you look at the judicial anthology of this law, unfortunately, almost 97 years old, only 7 judgments have come out. I was examining why reason of petrology of those judgments to speak to you on an issue which is a very important issue. The issue is that the law was brought to restrain child marriage. Then, as you know, Pakistan Constitution started as a sovereignty of Allah as a preamble. And Article 2 is the Constitution, is Islam is the religion of Pakistan. When you look at it carefully, the reason these judgments are examining that, what can I speak to you? Because I have to explain the Constitution, Article 35 itself, gives an obligation on a state to protect family, mother and child. And whenever we're giving judgments on the constitutional law on child, I always tell the issue that child is a word written in the Constitution. Child is sometimes referred in the guardian law ward, sometimes a minor, sometimes a teenager. Various laws have different meanings of it, and the Constitution of Pakistan recognizes the word child. Child was brought into the 18th Amendment by mentioning that every child in Pakistan is subject to the compulsory and free education. So the child has a fundamental right. It has a right of dignity under Article 14, which is, if you look at, if people are speaking all over the world, people say, I said, my constitution is the best constitution because there's only one article of the constitution doesn't have subject to law, and that is dignity. Article 3, exploitation. And those rights have been in the 76 Constitution, they were in 62 Constitution, they were in 56 Constitution. But look at the judiciary, the cases brought to judges, you can't blame judges on that. The law has to have an FIR against parents who having the children been getting married. There is a mechanism in the law. Only Punjab amended to extent of the penalty or punishment. None of the provinces has taken this after the 18th Amendment. The list is now a content list. What is the issue? I must tell you all that 64 Dhaka judgment, 29 the law came through pre-partition, 69 Dhaka judgment. The division bench of the East Pakistan, the then East Pakistan, upheld the conviction against the parents. Because if you get your daughter married, you go to FIR. And those, when they upheld, the courts gave a very good judgment. Then at 1970 Supreme Court, one judgment, and then Justice Shahid and Justice Abdul Abbas. But the best to know is the federal judiciary. My answer to Nida is that look at the Constitution, which gives it individual rights to be treated as per law. It's a state duty. There's no FIR registered, unfortunately. There is no neighbor or relative going to courts to say, look, they're doing something. I have set up a committee in Islamabad. Raza is sitting here. She's a part of that committee. The committee is that we were looking at Nikah names. And they were all wrongly translated into Urdu. And I got the federal government to establish a committee. And we finally found out that we have to add things. And we need to put, we are now revising the columns 15, 16, 17, 18, 19, 20 of the Nagarnama made under the Muslim Family Law in 1961. Now we will, this, after coming and learning from doing research on this, will have their compulsory section in the Nagarnama mentioning the 18 years in the ID card. So you cannot get a marriage because marriage in Pakistan has to go through Rule 5 of Schedule 1 of the Muslim Family Law Ordinance 1961. Otherwise the Nagar or whatever is not valid under the Constitution of Pakistan. So the answer is, looking at it, that you have to first examine whether who is doing the Nagar. No FIR case. This case of this is Shahid Kareem was a case where somebody brought the case to the High Court because girls don't have age, guys have age, why can't you go for discrimination? This is discrimination Article 25, that is the judgment. Then the judgment of Shahid Court is the best one, is the best one. I learned something from it where the Shahid Court has said that you have to educate the parents, educate the girl. They have quoted hadiths and all, and they have said majority of the world have the same issue. The way forward is only one. Some have more daughters, and some do have good proposals. What is the way forward? You can't say no. The answer is, which is the full bench said, you have to take a permission from the family court or the Sharia. Family courts are established in the West Pakistan, Civil Family Code Act 64. They have a jurisdiction. Now you can go and say, okay, fine, if this is the issue, based on some hadiths, because all the Shia court judgment is detailed judgment, quoting the entire hadiths and entire theological parts of the Islamic law. So Islamic law has to be confined to, because we cannot make any decision in Pakistan which is against the Islamic principles. Article 2A is religion, is Quran and Sunnah, and we have to follow our faith. And our faith is based on what is the traditions are there and recognized principles. So Sharia Court found out that you can ask and you can seek the permission, and he is mentioned in his last paragraph that in the world they have going to courts and asking this issue because mostly Islamic countries have also prohibited. You mentioned some countries' name, and that is the last thing, but I'm saying, so we have hope. We have to ask government to implement this law. Unfortunately, I'm hearing 27th Amendment bench. We don't have powers to move the power. And had we been given to move the power, we could have taken action against. If this is the marriage happening, take action against it. So we don't have power because under Article 26th Amendment, which is 27th Amendment, 26th Amendment confine us, the courts, into one Article 1A. 1A says for the removal of doubt, the High Court can only decide the cases as per the pre-made hearing. So I can't go beyond the Article 1995. I am not assuming the Supreme Court judge to take action against a child marriage happening in some area. I read in the newspaper and take action. That is gone now. Which is now, we have federal court, we have a high court, in Article 175E, we have only jurisdiction. Thank you.
Recently, UK allowed, till very recent, a 16-year-old girl to marry with her parents' consent. So every country is very to this. There's a part of the civil society that believes that because of segregation between sexes, girls who marry, they are self-arranged marriages, and you should recognize that autonomy, even if they are underage. I don't agree with that mindset, but this mindset does exist. So coming now, we are going to a rapid fire round because we have very little time left. So let's make it 2 to 3 minute responses. So coming back to Justice Jawad Hassan, given Pakistan's binding obligations under international human rights law, to what extent can and should courts rely on instruments such as the Child Rights Convention and CEDAW to interpret Western law in a gender-responsive manner and to prioritize the best interests of the child when adjudicating child marriage cases? The question should be longer than the answer.
The answer is that Pakistan is the holistic and transformative country, unlike the France and Germany, which have holistic theory in international law. Under the Vienna Convention 61, Pakistan when if he signs a treaty and ratifies the treaty under the Constitution, 4th schedule, we are binding them. The question is that courts have very good respect for international law as binding. Some courts have taken the approach that the country signs, ratifies that treaty, and it's a mandatory to incorporate into a domestic law. Sometimes we have not done so, and courts corrective remedies. I have done it in 2 cases under social justice where there was no legislation and they were binding commitment under the mandatory convention or treaty under international law, and we cast it up to sit down and make the law on that with as a respect. Lastly, to that as EU GSP Plus, when we are filing our documents, our directing report coming as such, my work was to do Pakistan, how look Pakistan good looks. Pakistan looks excellent international because all international treaties, conventions on human rights, we have signed those, we have incorporated those, we have brought so many laws in Pakistan. We are a country, and judges are also, Babra is even a judgment which we talk about all over the world, that some treaties which are binding hardcore international law, we go further. We have even taken the soft law of international law as a principle of policy, brought into a domestic law, that is Babra. Clearly that is good. Where we have gone further toward, the principles is good. We brought to a Pakistani system, and the Supreme Court brings it under Article 189, which is binding on every court to follow that thing.
From the law system should ensure that